Now, to that end, the annual Rauh Lecture is an opportunity for all of you to hear from prominent lawyers and public servants who have in their own unique and powerful ways taken up Joe's mantle of public interest in their careers. This lecture is meant to inspire, to make what you are learning here right now a little more real and concrete, and to rejuvenate you, because I know from my own experience that sometimes law school and public service itself can be a bit of a slog, okay? I'm pleased to introduce tonight's Rauh lecturer, Senator Elizabeth Warren. Senator Warren is widely recognized as one of the nation's foremost experts on bankruptcy, commercial law, the financial pressures of middle-class families, and lending issues. She has dedicated much of her professional working life to ensure that our economy works for everyone, not just the wealthy and executives on Wall Street. She recently said in an interview, and I quote, "This is the work America needs to take on, the work of making certain we strengthen the middle class. This country should not be run for the biggest corporations and largest financial institutions." And she reinforces that message every day that she serves in the Senate. Now, she's a passionate advocate, guys. I mean, you have her bio, you can read about what she's done, but she is a passionate advocate for our country. I'd encourage you to go up on YouTube and look at a floor speech that she gave just 2 nights ago in response to the pending shutdown of the federal government. It has gone viral because the entire country is inspired by her willingness to call it like it is and to speak truth to power. So we really are pleased to have you here. Now, I won't say anything about her bio because you can read it, but 2 things are important. Time magazine underscored her role as one of the world's most influential advisors and people. They did that twice. The National Law Journal has honored her as one of the top lawyers of the decade. It doesn't happen by accident. It's the work that she does. Now, I've had the pleasure of knowing Senator Warren for many years and having first met her 20 years ago, and I'm going to summarize this and get it done very quickly. I would only say this. She came forward 20 years ago when I headed the Washington Bureau of the NAACP. She gave me advice and counsel at a time when we needed the kind of intellectual heft she brought to the table. And she did it consistently, not just with organizations like the NAACP, but grassroots groups who were trying to basically, work to advance the economic interests that we share in common. And our work together on the FDIC's Advisory Board on Economic Inclusion, which is where she hatched the idea of a federal agency that would be devoted only to consumer advocacy. And I had the opportunity to talk with her and people like Martin Eakes, who is head of Self-Help Credit Union in North Carolina. It was the senator's development of these issues that was so extraordinary. So it went from concept to advocacy to a reality. And it happened because of her passionate commitment to justice and doing the right thing. It's great to have the Rauh Lecture Series to showcase people who bring such extraordinary substance and commitment to the table. This year is a special privilege because I have the honor of calling Senator Warren a friend. It is terrific to be able to welcome you to the David A. Clarke School of Law. Thank you for taking time in this really challenging period to come forward and to join us. Please help me welcome Senator Warren to the table.
You're just the best. You're the best. Thank you. Thank you. Thank you. I can't tell you how delighted I am to be here tonight with you. Under all the circumstances, I am still very, very pleased to be here. I want to say thank you very much to President Lyons. God bless him. I hope that he's able to arrive at a good conclusion here. Dean Broderick, thank you very much. Michael, thank you very much for your kind introductions, for your invitation for me to be here tonight. I want to say a very special thanks to Wade Henderson. I would describe our long-term relationship a little bit differently. I came to Wade with ideas, but not sure how to turn them into reality. And I asked for help. And Wade was there time and time again. A patient teacher, but more importantly, a ferocious fighter. And it has been a deep honor and privilege to fight shoulder to shoulder with you, Wade, since we were children. So, thank you, Wade. Thank you. I also want to say what an honor it is to be here, to be able to deliver a lecture named after Joe Rauh. Throughout his career, Joe fought to level the playing field for the underdogs in our society, whether it was on civil rights or fair housing, the labor movement, or political advocacy. Joe was on the side of the little guy, trying to make the country just a little more fair and a little more just. And so that makes today a good day to talk about Joe's legacy, because we are now in the second day of a completely unnecessary and completely avoidable government shutdown that is hurting regular folks around this country. Nearly a million federal employees are sitting at home for no reason. Life-saving medical research has been halted. Veterans' benefits are at risk. Food safety inspections are being stopped. Basic nutrition services for pregnant women and new moms are about to be disrupted. Small businesses aren't able to secure federal loan guarantees. All of this and more. Why? Because Republicans in the House of Representatives have refused to keep the doors open and the lights on across the entire government unless the President of the United States agrees to gut the Affordable Care Act. Well, that's not happening. The Senate has rejected these threats, and it will continue to reject these threats. The ACA is the law of the land. Yes. I don't know about you, but it just gave me goosebumps to hear this morning that millions of people are already trying to log on to the ACA healthcare marketplaces around the country. These are people who need healthcare coverage, people who need insurance policies that don't disappear when people are at their sickest. Women are finally getting insurance coverage for birth control. The law is here to stay, and it will stay. The time has come for these legislators who cannot cope with the reality of our democracy to get out of the way so that people of both parties who understand that the American people who sent us to Washington to work for them can get back to working on solving real problems faced by the American people. Joe Rauh's lifelong commitment to fighting back on behalf of the little guy and working to solve these problems is a model for every one of us today. On the most hotly debated issues of law and policy, powerful interests are organizing themselves to put serious pressure on Congress and on the courts to strip away some of the most important rights and reforms that we have fought so fiercely to win. You know, let's be clear. Here in Washington, power is not balanced. Instead, power is becoming more concentrated on one side. There are well-financed corporate interests lined up to fight for their own privileges and to resist any changes that would limit corporate excesses. You know, I saw one example of this up close and personal following the 2008 financial crisis when I fought against the biggest banks for stronger financial regulations. But believe me, there are many more examples. You know, in our democracy, when we write the laws, reasoned debate, public opinion, and political accountability are all factors that can thwart the efforts of big corporate interests. But even if big corporate interests lose the fight in Washington, and yes, it can happen. If you think it can't, just remember, NLRB, EPA, Consumer Financial Protection Bureau, and now the Affordable Care Act. We can win. But what happens is that when we win, well-financed corporate interests know that they can turn defeat into victory if they can get a favorable court decision. If they can rig the courts, then a friendly judicial system will give them a second bite at whatever they want. It's because of that that there is an intense fight going on right now over what the federal courts will look like. It's a fight over whether those courts will remain a neutral forum, faithfully interpreting the law and dispensing fair and impartial justice, or whether we will see the corporate capture of the federal courts, with the courts transformed into just one more rigged game. Right now, we are losing that fight. So I want to talk tonight just a little bit about the reasons. Consider the composition of the federal bench. Look closely, and you will see a striking lack of professional diversity among the lawyers who serve as federal judges. According to a study published by the American Constitution Society, as of 2008, the federal appellate bench was, quote, dominated by judges whose previous professional experience is generally corporate or prosecutorial. The study examined the biographies of 162 judges listed in the Almanac of the Federal Judiciary. It found that 85% of those judges had worked in private practice, and it also noted that it was, quote, clear from the judges' biographies that a sizable number of them worked for large, well-known firms that tend to represent corporations. Now, since taking office, President Obama has been responsible for some notable exceptions to this trend. District Court Judge Edward Chen worked for many years as a staff attorney at the ACLU. Generally, however, even the president's appointments have been in line with prior statistics. Now, I want to be clear. There are some really, really talented judges who come from the private sector. I know that. I myself have done some work for the private clients. And it is, of course, true that the personal views of attorneys often diverge from those of his or her clients. But I think diversity of experience matters. At his induction ceremony, Judge Chen was quoted as saying that he never considered withdrawing his name from consideration because, as he explained it, I believe that someone should not be disqualified from the bench simply because they once represented the voiceless and unpopular rather than the wealthy and powerful. Well said, Judge Chen. Today, we are at a unique moment where we will have a chance to add some diversity of legal experience to the D.C. Circuit, which hears most of the appeals of agency decisions and has often been called the second most important federal court in the land. Some of the most consequential decisions of our time, the decisions about whether Wall Street reform will have real bite or whether it will be toothless, are only now bubbling up through the D.C. Circuit. Some have suggested the D.C. Circuit doesn't need any more judges, even though there are currently 3 vacancies on that court. You know, the next time you hear someone make that claim, you might remind them that the president with the most appointees on the D.C. Circuit right now, the president with the most appointees is Ronald Reagan. It's been 25 years since he last made an appointment to that court. Think about that. President Obama has nominated 3 outstanding nominees to fill the vacancies on this court. One of the nominees, Patricia Millett, has argued a whopping 32 cases before the Supreme Court. The second nominee, District Court Judge Robert Wilkins, has spent 12 years working for the Public Defender Service here in the District of Columbia, and 8 years after that at a major law firm. The third nominee, Professor Nina Pollard, has been the subject of heavy partisan attacks. Professor Pollard is among the most accomplished appellate advocates of her generation. She has spent years working for the Justice Department and has argued 9 cases before the Supreme Court. She has also spent 5 years working for the NAACP and has served as a professor at Georgetown since 1997. Despite the fact that Professor Pollard has not spent years at a large corporate defense firm, there can be no question she is highly qualified to serve. These 3 individuals represent the best of the legal profession, and nominees like Judge Wilkins and Professor Pollard would bring significant professional diversity to the D.C. Circuit. All 3 nominees deserve an up or down confirmation vote as soon as possible. Absolutely. Beyond the district courts and the appeals courts, there is another reason that we are at serious risk of losing the neutrality of our judicial system in the increasingly brazen and ideological pro-corporate tilt of the United States Supreme Court. 3 well-respected legal scholars, including Judge Richard Posner of the 7th Circuit, widely respected conservative Reagan appointee, recently examined, these 3 scholars recently examined almost 20,000 Supreme Court cases from the last 65 years. The scholars used multivariate regression analysis to determine how often each judge had voted in favor of corporate interests during that time. Judge Posner and his colleagues concluded that the 5 conservative justices currently sitting on the Supreme Court are in the top 10 pro-corporate judges in half a century, and Justices Alito and Roberts, number 1 and number 2. Think about that. Take a look at the win rate of the Chamber of Commerce. The Constitutional Accountability Center has shown how the Chamber moved, now watch this, from a 43% win rate during the last 5 terms of the Burger Court to a 56% win rate during the first terms under the Rehnquist Court to a 70% win rate so far with the Roberts Court. Follow this pro-corporate trend to its logical conclusion, and sooner or later you'll end up with a Supreme Court that functions as a wholly owned subsidiary of big business. We can't do that. The consequences of this pro-corporate shift are staggering. The Affordable Care Act came within an inch of being invalidated by the Supreme Court. Citizens United unleashed an avalanche of secret corporate money into our political system. The Voting Rights Act has been gutted. And other less prominent cases are just as damaging. In the Lilly Ledbetter case, the Supreme Court chose to protect employers over employees, ignoring the basic principle of equal pay for equal work. The Supreme Court rewrote our established understanding of the standards for filing lawsuits in the Iqbal and Twombly cases, making it easier for rich corporations to beat poorer underdogs. The court looks for every opportunity to undermine class actions, and that leaves big corporations free to roll over millions of people. Whether it's in the district courts, the appeals courts, the Supreme Court, we don't need judges who put a thumb on the scales of justice for either side. We just need justices who will be fair, judges who will be even-handed, and judges who have the experience to understand and consider all sides of an issue. At every level of the judiciary, It's time for a new generation of impartial judges, judges whose life experience extends beyond big firms, federal prosecution, and white-collar defense. We need sustained pressure to get those judges in front of the Senate. Pressure on our president, pressure on our senators, pressure in the press. And if the judges don't get a vote, if they are blocked, if they can't get through, we need to change the filibuster rules to get them through. We need a new generation of judges on the bench, and we must prevent the corporate capture of the federal courts. I don't kid myself. Change is hard, but we need to get back to the business of making government work for people, not for big corporations or special interests. The people in this room and the lawyers all across the country who are committed to public interest law and social justice are tough, resourceful, and creative. I believe in what we can do together. I believe in what we must do together. Thank you. Thank you. Thank you.
Thank you.
Thank you. Thank you.
Just stay right here, please. Senator, thank you so much. If I may just add one political footnote, I thought you were going to go there. But what is really, really, really important is in 2016,